actually is a pretty significant question that you asked there. Like, one, a police officer, no matter whether they're engaged in one traffic stop or another, they have to conduct business, but they can, I've seen police officers be in the middle of giving somebody a traffic ticket and somebody drives by and gives the dude a finger, and they stop everything they're doing to go chase this guy down, okay? They literally leave their own traffic stop to go and then start a whole nother investigation, okay?
Yes, yes.
So, I've seen this take place, and then the video I just sent you, a guy left his van to go communicate with the police and basically question the validity of the stop and just really kind of, put the cop on edge. He's auditing the police officer. He's auditing the stop. It's what we actually have a right to do, is to film all public servants. Right. I highly recommend downloading the PDF and including just, looking it up online, the 1820 Constitution of Maine. Okay?
I may have to download it, actually. I'll have to go back and look.
And read it every day, a couple, or every once a week, or read it and keep yourself really refreshed. And, I got a lot of recordings that actually, use this as my model of foundation that sends me into the next direction, which is, making our public servants be public servants. Treat us as real people, okay?
Yeah,
so, in Section 2, okay, Section 2.
One quick thing. So does the 1829 Constitution of Maine, is that what we're still, Maine still uses today?
Yep, that's right. It's the 1820 Constitution of Maine, as well as the continental United States of America, the Constitution of Washington, District of Columbia. Because there's a state constitution and a constitution for the District of Columbia, which is the United States, that binds them in a contract, okay, within that constitution. But that Bill of Rights really is a compact charter that models each state constitution. Each state was actually a part of a confederation, and they all had their own charter to be a part of a union. And it was the compact under these constitutions is what made us under a union. Do you understand?
Yeah.
So, right away, let's say I pull up, okay, here we go. Okay, so, starting right off, where is it? Okay, so this is the Declaration of Independence. See, I write a lot of stuff down for not argumentative purposes, but legal, lawful defense mechanisms moving forward. Pretty much like you said, you want to defend yourself, which is really the reason why I'm writing this book that I'm writing, is to help people just buy the book and read the law. Like, read it right there. There's a script for, you know what I mean? But,
yeah, so it's already in a place. You don't have to go look for it everywhere.
Yeah, it's all right there. So, Article 1, Section 2, out of the Maine State Constitution of 1820. All power is inherent in the people. All free governments are founded in their authority. Whose authority?
Our authority.
Mm-hmm. And instituted for their benefit, and have therefore an unalienable and indefeasible right to institute government and to alter, reform, and totally change the same when their safety and happiness require it. So, whenever I meet these officers or these people, I try to get them to understand that.
Yeah, my internet here.
It's okay.
I'm here. I'm back though.
So, I usually start off with that section and then begin to let them know that I am of the people and I am now reforming the government right now as we speak, to fit me. Not them. Me. That,
yeah, so I see what you're saying. Almost like,
well, I'm reforming in altering the government to fit me right here, right now. This is what they need to do. If they don't, they have a civil lawsuit. I'll sue them.
Oh, that's what you're doing with the secured party creditor and your own nationality.
Mm-hmm. Yeah, because I'm not a 14th Amendment citizen anymore. Or I never was, but no, I'm really not. So now I'm one of the people of the several states. I'm in a separate jurisdiction outside of jurisdiction. Imagine it like this, all right? The country was one great country, okay? Then we have a war. This war creates a new government. And through this new government, we now have a new citizen. Through this new government, it has legislative and congressional authority through consent in each state that allows it to have a contract with that. So between each state having a relationship with the federal government, which is Washington, D.C., makes them also subject and under the jurisdiction of the federal government. So there's two states. You have the Maine Republic or Maine state, and then you have the state of Maine. Okay? So one is of the government of the people by Maine state, okay, which is by the people, Maine nationals, the people of Maine. They have their own nationality. They have their own government. It actually has its own treasury there. It has everything that a government would model in Washington, D.C. Every state has their own. So the federal government, through little by little, by benefits and specific things, has basically taken over state legislation. So they're not going to educate you how to be free. They're going to educate you to be a slave.
Yeah.
Okay? So in this book I'm reading called The Law of Nations, it talks about how a nation is also a people. So you're a nation walking, okay?
Yeah.
But a nation is also a motherland of Maine. Okay, so let's look at Maine. Instead of a state, it's its own nation, okay?
Like its own person, almost.
It's its own entity. It's a female. Every nation is a woman. It's a female, okay? So she's alive. Let's look at her as the motherland. That's why I said the motherland, because she's a mother, okay? And we walk upon her lands, and she is her own entity. She's alive, but so ain't you, okay?
Right.
And you walk this, and you have free domain here under biblical treaty of, I'd say, Genesis 2, and also in Psalms 9, chapter 9. I'll pull it up right now. So, Psalms chapter 9 says, it might be 8. It's 8. It's Psalms 8. O Lord, how excellent is thy name in all the earth, who hast set thy glory above the heavens. Out of the mouth of the babes and sucklings hast thou ordained strength because of thine enemies, that thou mightest still the enemy and the avenger. And when I consider thy heavens, the work of thy fingers, the moon and the stars, which thou hast ordained. What is man that thou art mindful of him, and the Son of Man that thou visitest him? For thou hast made him a little lower than the angels, and hast crowned him with the glory and honor. Thou madest him to have dominion over the works of thy hands. Dominion. Domain. Dominion goes into rulership. It's a kingdom.
Yeah.
All right?
Like in charge. Almost.
Has put all things under his feet. So we're in charge of this stuff. Okay? So what's under the feet? Obviously now this is talking about the land. All the sheep, yea, and the beasts of the field. So this is the law of the land. The fowl of the air, that's the jurisdiction of the air. And the fish of the seas, talking about the jurisdiction of the sea. And whatsoever passes through the paths of the seas. So he's telling you, O Lord, O our Lord, how excellent is thy name in all thy earth. So he's telling you in Psalms 8 and in Genesis, I believe it's 2:9. I could be wrong. Might be even 2:3. So we'll go to 2:3 first. 2:3. Okay, so what did I say? 6 or 2-9?
2-9.
Okay. I'm wrong on both factors. So we're going to go ahead. It's actually 1:26. Okay, and he says, God said, let us make man in our image, after our likeness, and let him have dominion over the fish of the sea. There's the jurisdiction of the sea. Over the fowl of the air, there's the jurisdiction of the air. And over the cattle, over all the earth. So there's the jurisdiction of the earth. And then the next one would be the heavenly celestial kingdom, where Jesus is, and that's the other jurisdiction. So there's 4 tiers of really just jurisdictional powers in the world. And so essentially, when you're on the motherland, you're on the jurisdiction of the land, and you come from the land. So you have domain over that, primarily, rightfully so. So then the government was created, and it created its own state, and the state can't interfere with the jurisdiction of the nation. You understand?
Yeah.
Because now the nation owns the state. The nation is actually above the state. And then the state now has its own jurisdiction and authority. And it's going to have its own subjects. And that would be its citizens. So essentially what Maine state did was create a separate state within the nation of Maine, and has its own subjects and citizens that it's telling what to do and proposing all its ordinances and regulations and things that it's subject to through policies, which most executive orders only apply to immigrants. So, because you're a U.S. citizen and not an American, the Emancipation Proclamation Act during 1871, when Abraham Lincoln freed the slaves, he made them all United States citizens, thus making them subject, okay, to all the policies. So when the president passes all these executive orders, it applies to the immigrants, which are also U.S. citizens, because they're not from here. They belong somewhere else. They don't belong somewhere else because really, technically, the only right of a U.S. citizen is the right to be here, okay? Everything else is a privilege. So what they did was convert Americans into U.S. citizens, thus giving up all this real, true, God-given natural rights over for civil liberties. Civil is another word for contract, or admiralty, or maritime. So going back to 1666, when they created the Sestaquavee Trust, it says that everybody's dead at sea until they claim themselves back. So now this is how commercial activity operates, that even you, by the state, are looked at as commercial property. That's why they look for your ID. That proves that you're property to them. It's your state ID.
That's why that's the first thing they always ask for.
Absolutely. So they get you to violate your own rights.
Yeah, they pretty much walk you right into it almost.
So the next factor is going to be, well, the Fourth Amendment. The Fourth Amendment is really the one that comes in with, like, in fact, I just was looking this up yesterday. So you have penal action. Penal action falls into admiralty maritime law, condensed into uniform commercial code through penal actions, okay? Penal action leads to an attachment. An attachment is also a warrant, okay? A warrant, all right? So when I'm actually dealing with the Secretary of State of Maine now, letting her know, because like somebody was trying to say, well, you have to register your vehicle. It's what everybody does. Well, no, because the moment that I do that, what I'm doing is I'm converting my personal property into equity law, and to cover the debt of the United States as a security interest through the attachment of me giving my property over to them. They're going to give me the attachment item, which is the registration piece of paper that's saying, hey, we get to charge you.
Yeah.
I get to tax you as a commercial entity. Does this make sense?
Yeah. Pretty much we own the car, you don't.
That's exactly what they're doing. So it says, the right of the people to be secure in their persons, okay, that's your corporate self, houses, papers, which is all your registration and your driver's license and all that stuff you shouldn't have to get, and the effects thereof, against unreasonable searches. So remember, they have this thing called reasonable articulable suspicion. Well, suspicion is still not a crime.
Right.
Okay? But do you have reasonable cause, probable cause, and reasonable suspicion, a reasonable crime? There has to be reasonable suspicion that I'm committing a crime or I'm about to commit a crime. You still there? Okay, so it says the right of the people to be secure in their persons, which is their corporate self, their ego identity, their alter ego, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants, which are attachments, shall issue, but upon probable cause, supported by an oath or affirmation. Affirmation is like a real, actual affidavit of law, an indictment, something that is tangible and affirmative within the court of law that can actually be seen as real, actual truth, in an oath, and particularly describing the place to be searched and the persons or things to be seized. So this is where this is a very crucial element to, our court system is the Fourth Amendment, because it goes towards whether police have right to stop you, okay? Like, really? Oh, I saw you had a headlight out. Is that really a crime? And they'll say it is, but it's not. It's actually a traffic infraction. So it's not a crime. So they lie under falsified information, which is actually created as a de facto arrest. So if it's not constitutional, is why they pulled you over, or what they say is actually committing a crime, it's not. And if you could put them in their place of that, then you can start to unravel their little traps that they're trying to create for you, okay? So if they could if they could arrest you, they just arrest you. But if they don't, they're going to give you a reason that they're going to believe to arrest you, but it's not reasonable. So therefore, it would be a de facto arrest. Are you understand what I'm saying? Did you hear what I said or no?
They're going to give you they're going to create a reason, like they create their own suspicious reason to continue with the search.
And if it's not reasonable, then to law degree that leads to a real actual de jure arrest, lawful arrest, then the whole thing will be thrown out and you can open up a lawsuit and actually sue the officer that arrested you, okay? So
and that's what you have to do, is create a civil lawsuit.
That's right. And let them know that you're going to do this stuff in the beginning. If not, then they're going to presume through acquiescence, your silence is your consent, and by you not invoking your rights. Like, I remember some point, I think it was 1998, right around there. Might even been maybe 2000, after 9/11 a little bit. But right around 1998 going into 2000s, there was a news article that came in Maine and said, if you don't invoke your rights, you don't have any rights anymore. That if you don't invoke your Fifth Amendment, then they're going to assume that your silence is actually consent.
Wow.
Yep. And then
I understand that, because the Fifth Amendment is like the right not to have to answer any questions.
That's right.
But if you do this, then this will actually maybe benefit them. Like if you don't say like if you don't protect yourself right when you start the traffic stop, your silence will be used for their advantage.
Yep. So it's not just anything you say will be used, it's everything that you also don't say.
Yes, yes.
So I got this manual here that I picked up. As soon as I started to study the law, I began to discover, I wanted to know all the laws. And so I bought this Florida statute. It's a Florida criminal law and motor vehicle manual. And it has inside it, at least during this time, to 2017, legal guidelines. So these are, just like if you were going to become, a chef or anything, there's a job description. There's requirements, there's guidelines, there's things that you need to know to be a chef, or if you were going to be an insurance adjuster. So these are all the do's and don'ts and ins and outs of becoming a police officer, of the key components that you need to know. And so reasonable suspicion. So here we go. At least what it says, the next higher level of contact a law enforcement officer may have with a citizen is reasonable investigatory stop, i.e. a Terry stop. Probable cause is a higher level of contact than reasonable suspicion. Factors to weigh in determining if reasonable suspicion exists include the following: time of day or night, the day of the week, the location, the appearance of the suspect, the appearance and operation of any vehicle involved, and anything incongruous or unusual. Okay, you still there?
Yeah.
Incongruous or unusual in the situation as interpreted in the light of the officer's knowledge. This is Hernandez v. State 784 SO.2D 1124 in parentheses FLA.3D DCA 1999. It is important to remember that an officer's training and experience can be taken into account in determining whether reasonable suspicion exists in a given situation. U.S. v. Arizona 534 U.S. 266 in parentheses 2001. Probable cause has to be distinguished from reasonable suspicion. So just because you pop up doesn't mean you have probable cause yet. Probable cause has to be distinguished from reasonable suspicion. So that's where they get reasonable suspicion in the Fourth Amendment. Do you remember me mentioning unreasonable?
Yes.
So they're using the word reasonable from the phraseology. Their words that they're using is how they created a negative law on top of the positive law, which is your rights. Your positive law is the amendment that is protecting your rights in the Constitution. The negative law is the statute or whatever it is that's now being used as against you.
Against you.
Yeah, a recourse. So they're using the language in the Fourth Amendment, against unreasonable searches is where now they get reasonable suspicion. This is where they create reasonable suspicion now. So it says, probable cause has to be distinguished from reasonable suspicion in order to make an investigatory stop of a suspect. So really, without reasonable suspicion that's accurate, they can't just make an investigatory stop. Okay?
Right. They have to, before they even pull you over, they have to have an actual...
That's right.
Like an actual crime has to take place.
A real reasonable suspicion leading to a probable cause. And just because the suspicion is not a crime, and you do not have to assist them in their investigation.
So an odor of like marijuana, per se,
well,
that wouldn't be...
That is reasonable suspicion. At that time, that marijuana was illegal.
Yeah.
Okay? But you can roll up all your windows and only roll down one window an inch, and now they can't lie, because the only way you can get a backdraft is if one window's open. That if two windows are open, it can create a backdraft inside the vehicle. But if all the windows are up and only one window is down an inch and a half, just enough to slip a fucking ID through, you're good. You don't have to create space for him. So if he says, well, I smell cannabis or something, that's a bald-faced lie! You're trying to implicate me in a record to gain reasonable suspicion and probable cause to investigate my car, and that is a bald-faced lie, sir. I request your supervisor out here, and I request that you stop and detain it, and be just as aggressive as that. Let them know. They're lying.
I know that I'm in control.
That's right.
Not you.
Yep. So they're trying to lie to gain probable cause to then access your vehicle, access you, access information.
Yeah,
it's
and
just
they're going to be like, well, we can't hear you. Well, I can hear you. As long as I can hear you.
We can't hear you. Oh, are you sure? Because I heard you just fine.
Yeah, and you're hearing me.
Yeah, I just heard you say I can't hear you. Okay, maybe you need a Q-tip? You need a Q-tip? Sounds like hygiene problem something. Are you sure you qualified for the job?
Did you get your ears checked before you took this job, officer?
Right. You know what? It's not my job to see whether you're qualified to do your job or not, and it's not your job to give me unlawful directives.
Exactly.
Yep. So then, the law enforcement officer need not have probable cause to believe that a crime has been committed to it by the suspect. That's right. So, he don't need probable cause to believe that a crime has been committed by the suspect. All that is required is reasonable suspicion by the law enforcement officer, which is not necessarily a hunch. Okay? It's not a hunch. There has to be reasonable suspicion. These are the gray areas. This is a gray area that the court has created for officers to basically molest you, and this is why you need to just keep saying, I don't answer questions, you're not my friend, go fuck yourself. Yep.
You pig.
Yep. Well, I've learned to not be mean with them after my last, I'm not at war, they are, bro.
Yeah.
I'm not at war, man.
Treat them well. Yeah, I know what you're saying.
Meet them with peace. Meet them how you want to be met. That's where I'm at now, okay? And, you know, I could be wrong, you know? I know I'm going to meet. There's asshole cops out there.
It's gonna be even harder, you know what I mean?
Just remember, they're going to be a reflection of you, not these people, okay? They're meeting people how they've been met. Most people are criminals and they're not doing shadow work and they're not facing themselves. And then the ones that are, you can see the police treat them differently. They're stumbling all over themselves and fucking not knowing what, you know.
Not knowing what to say.
Yeah, how do we handle this guy? This guy's different than the other guys, you know? See what I'm saying?
This guy may be raising his voice, but he's in full control, and he's not being disrespectful. You can still be respectful and raise your voice, you know?
That's right. Thank you, Lord, for this cannabis. Thank you for this day. Bless you for my brother. Bless you for all. I'm working on trying to, you know, I realize I got a few things to get away from, but I got to be nice to myself about it. I guess I have an enabling spirit in us. We have an enabling spirit.
Yeah.
Forgive me if I resented, judged, and denied the enabling spirit in us. As I forgive those who have resented, judged, and denied the enabling spirit.
Yeah.
And then we'll go ahead and get into that. So I definitely want to talk about that, but just let me finish this, because this is actually why you called, or what you had these questions. And I'm recording this phone call, so at least this section.
Love it, dude.
Let's go. All that is required is reasonable suspicion by the law enforcement officer. Thus, probable cause requires a higher standard than a suspicion. What represents a reasonable suspicion to make an investigatory stop depends upon the facts and circumstances of each case. Cases which have held that the officer had a reasonable suspicion for an investigatory stop are as follows so this is a best case that they're using under the Hernandez versus State, which would be in Florida, okay, and they mentioned that one back at Hernandez versus State 784 S0 or SO.2D 1124 Florida 3D DCA 1999. And if you review this case, okay, it will give you major key outlines of how the Supreme Court has ruled in favor of this stop to then go towards reasonable suspicion and what actually gave this officer true reasonable suspicion that led to probable cause under the Hernandez versus State. So then it says, Supra, an officer responded to a 3 a.m. report of suspicious activity in the parking lot of an apartment complex. He saw a van in a parking space with another van backed up to it. The rear doors of both vans were open, okay? So it says the officer could reasonably suspect that the parked van was being burglarized, and therefore was justified in conducting an investigatory stop. So without reasonable suspicion, as we have discussed, there's no reason to investigate. You see what I'm saying?
Yeah.
So if a police officer is trying to investigate without reasonable suspicion, this motherfucker is actually violating your Fourth Amendment right. He's harassing you. He is violating 242 USC 18 241 242. And
we would want to like tell him this, like you're violating.
Yeah,
my
you
rights,
want to let
officer.
him know that this is exactly what he's doing. Yep, you want to let him know this is what he's doing, and that he's susceptible now to a class action 1940. It's a USC 42 1983 class action lawsuit, and there is. I'm looking for it right now. There's a couple of. Okay, so 1985 of the 42. Let me read these to you, because these are huge, actually. These are pretty big. So, we got the 1985 conspiracy to interfere with civil rights if two or more persons in any state or territory conspire for the purpose of depriving, either directly or indirectly, any person's rights, the party so injured and deprived may have an action for the recovery of the damages. And the 86, USC 4286, 1986, every person who have knowledge that any wrongs conspire to be done, about to be committed, or having power to prevent or aid in the preventing of a commission of the same, neglects or refuses to do so, if such wrongful act be committed, shall be liable to the party injured. So when other officers show up and help to assist conspire against the rights, that's a violation of 1986. So mention 240 USC 18241. USC 18242, that's 241 is conspiracy to go against my rights under color of law. 18242 is deprivation of rights under color of law. And then the 1985, which is essentially conspiracy to interfere with civil contracted rights and your rail rights protected under the Bill of Rights. You understand? So they're going to interfere with your rights. And if they don't have reasonable suspicion, that's exactly what they're doing. When they stop you, they're interfering with their rights. And you could let them know this. Hey, you know what? You stopped me. What is your reasonable suspicion to even give an investigatory stop? Okay? Well, I saw a headlight out. Well, that's really not a crime. I'm not operating at a for hire capacity or engaging in any kind of commercial use or transportation use of the highways. Please note that you've been informed.
Yes, I'm informing you that way. If he keeps and he proceeds, then you have action for a lawsuit.
That's right. So it says
for a lawsuit.
So he had reasonable suspicion to believe that a burglary was taking place when he saw a van with another van and two doors opened up. I guess to a degree they could have been moving, but it was 3 a.m. in the morning. You see how it said before, it says you need to configure time of day, night,
yes,
place, location, all these things to factor in reasonable suspicion before you could just investigate. So maybe at 3 o'clock in the afternoon, that would make sense being moving day. But 3 a.m., two vans? This doesn't look right. You see what I'm saying?
Yeah.
So
it's really important. Then
essentially that's what, and you know, this is their legal guidelines. This is what when they become a police officer, this is the book that they read. This is the book that's given to them. Okay? Cost me $200, cost them nothing but a fucking job application. So
wow.
It says this. So it says, okay. All right. The officer could reasonably suspect that the parked van was being burglarized and therefore was justified in conducting an investigatory stop. In State versus KV, that's K.V. 821 SO.2D 1127 in parentheses 4th, capital letters DCA 2002. An officer had reasonable suspicion to stop a vehicle following a tip from a guard at an apartment complex security station that she had smelled marijuana coming from juvenile KV's car. Compare with DH versus State, so DH versus Florida really what it would be, 121 SO.3D76 in parentheses FLA 3D, all capital letters DCA 2013, where an officer had reasonable suspicion to stop a group of juveniles when he smelled what he recognized as burnt marijuana emanating from the area near the group and noticed a puff of smoke hanging in the air near them. However, while a stop was justified, these facts did not give rise to reasonable suspicion to pat down the juveniles. But they'll use that.
Wow.
They'll use that. So really, that's a de facto stop, an unconstitutional, unlawful stop. It's harassment. It's trespass. It's an so.
So in order for him to have done it correctly, he would have had to like actively seen them smoking it.
Yes, exactly. Which now is beyond. That's now probable cause. Now that leads right from reasonable suspicion. So let's see why. In Blythe versus Florida, 825SO.2D447 in parentheses FLA.5th, capital letters DCA 2002. Officers saw a car parked in an improper area outside a closed business at 1:30 a.m. As the officers approached the car, they saw the butt of a gun inside it and partially concealed by clothing. The officers had reasonable suspicion to detain defendant by asking him to step out of the car and asking him why he was in the area. So, because they saw the gun, they believed that they had reasonable suspicion to detain the defendant and asking him to step out of the car.
Just for seeing a gun.
Just for seeing the butt of a gun.
But you can have a firearm in Florida.
Yeah, you can.
Right? Yeah, that's what. Like anywhere almost, I feel like near U.S. Yeah, wow. So just for seeing the gun, he ripped the guy out of the car.
But that's given them reasonable suspicion to now do an investigatory stop.
Wow.
So let's get into this de facto arrest, because right there was reasonable suspicion.
They arrested him too?
Well, we were just talking about reasonable suspicion and examples to give reasonable suspicion. So we never went into the follow-through of the case. We were just talking about examples of specific cases that have taken place that signifies what reasonable suspicion really looks like. Okay?
Yeah.
And that's a couple of factors. And it does go down for quite a while. I'm not going to continue reading. I mean, it goes on for a long time. So we're going to go into now cautions to observe and de facto arrest. Cautions to observe. One of the most common pitfalls in the area of reasonable suspicion and probable cause is the timing of an officer's arrest. In his or her zeal, an officer frequently acts prematurely and as a result nullifies what might have been a valid arrest. Thus, an officer may have grounds to approach an individual to question him or her, and may even have reason to stop a person in order to obtain information. Swartz vs. State 857SO.2D950 in parentheses FLA.4th, all capital letters DCA 2000. Certain officers, based on a hunch or a gut feeling that the individual is dirty, will search or arrest the individual before they legally have grounds to do so. And many officers feel that the results of the search will justify the police activity. However, the courts have made it quite clear that a bad arrest or a bad search cannot be salvaged or corrected by what the officer recovers from the suspect. Just like me and you, like in life, we go make a boo-boo, and we have this feeling of regret, and we want to go back and fix it, and we may be able to learn from it and heal, but it doesn't fix what happened, does it?
Doesn't
No.
change, yes.
So that means that life is in real time all the time. So we make these irresponsible or, ignorant decisions that lead to ultimate consequences at times. And, God may be merciful, but from what it sees in the court's justice system, these are the factors of real time during these investigatory stops that they cannot turn back the hands of time. Everything's fucking crucial. Every step of the way. Therefore, a police officer...
to have the time of day, if it was raining, if it was snowing.
Everything.
Everything.
The fact that, let's say you're in a vehicle, I ask you to leave the vehicle, you told me, so I'm doing, let's say I pull you over for the idea of a suspicious of a DUI, and it's cannabis, not booze, because they're doing DUIs on cannabis now. So I get you out of the vehicle You say you do not consent to a search, but I'm zealous anyways, and I search your vehicle anyways, and I find cannabis, okay? The whole entire stop is thrown out.
Because I said I didn't want you to go
That's
in
right.
the car.
You did not give me permission to do these things, and the body cam shows this. So, therefore, a police officer must proceed very carefully when approaching an individual on the street or in a car. The officer may only intrude upon the individual's privacy to the extent permitted. That's interesting because people are not told that they are, you know, an officer is only allowed to be around this individual like a vampire. Ha! They're not allowed in your house unless you consent. They're not allowed to talk to you unless you allow them to.
Right.
So they're not your friend. They don't hang out on Friday nights. Do they call you up when you're down and ready to eat a bullet?
No, anytime I've ever dealt with the law enforcement, it never ended well for me.
Like, well, are they ever your friend? Do they really care about you? You ever get the feeling like they care?
No.
No. But yet they always say they're there for your safety. We're here for your safety. You'll thank us later after this gaping asshole and blood coming out of your fucking unconsensual ass of rape and piracy.
And your wrists are all fucking bloody. And
well, that's a part of us raping you.
And pretty much, you know.
Yeah.
An unlawful fucking rape.
An unconsensual rape. Yeah, you didn't want that. It happened. And then they say, you'll thank us later for it. After we destroy your whole entire life. You know, like...
Oh, man. These people are like believing.
The officer can only act in the relation to the information he or she possesses at that time. If the information he or she possesses does not constitute probable cause to arrest, the officer must not act prematurely and cannot take the person into custody. A law enforcement officer should proceed with questioning, surveillance, or other appropriate police work, which can culminate in probable cause. So here we go. De facto arrest. This is where you want to be. So this is the next amazing factor to consider when considering an arrest.
No, de facto, that's like false.
Well, let's pull up the word de facto so we're all on the same page. So me and you, I'm going to share my screen with you. Share. Sharing. Start now. So, can you see my screen?
Yep.
Okay. We're going to go into documents. We're going to go into SD, right down here, dictionaries, okay? And we'll pick the Anderson 1889 version, okay? This is a really good one. It's very concise. Come on, friend. Oh, great, we're in D's too, so that's good.
Wow.
We're in D's, so that's nice. So all I have to do is look for the F. A, B, C, D, E, F, G. So we're heading. Here it is. Yep, we're getting close. We have deface. Okay, so they don't have de facto here. So, yeah, they do. Yeah, they do. It's got to be over here somewhere. Nope. Deface. Nope, they don't. Okay. So there's no de facto in this dictionary. So we're going to go into 1979, 5th edition. And here we have where I was looking at penal laws and penal action and how basically, essentially, through a penal action, you're being sued by the state. So they're suing you for crimes, victimless crimes. You're being sued. So, A, B, C, D, E, F, G. Okay, I went too far. We're almost there.
No rush, man.
De facto. Okay, you see this? De facto. Deface. Okay, so this is... All right, here we go. In fact, indeed... actuality. This phrase is used to characterize an officer, a government, a past action, or a state of affairs which must be accepted for all practical purposes, but is illegal. or illegitimate. Thus, an office, position, or status existing under a claim or color of right, such as a de facto corporation. In this sense, it is the contrary of de jure, which means rightful, legitimate, just, or constitutional. Thus, an officer, king, or government, de facto, is one who is in actual possession of the office or supreme power, but by usurpation, or without lawful title. While an officer, king, or governor, de jure, is one who has just claim and rightful title to the office or power, but has never had plenary possession of it, or is not in actual possession. McLeod versus United States, 229 U.S. 416-33 S.CT.95557 L.E.D. L.E.D.1260. So let's go to de facto government. One that maintains itself by a display of force against the will of the rightful legal government and is successful, at least temporarily, in overturning the institutions of the rightful legal government. So, does this sound familiar? So let's.
Is that like us? Or
yeah, it's our very exact government that we have today. Let's go into de jure, okay? Because it mentioned the word de jure. So, de jure. There it is, right there. You see it?
De jure, yep.
Yep.
Oh, there we go. I can see it good.
Descriptive of a condition in which there has been total compliance with all requirements of law. So this is where the people need to have and fulfill all the total compliances and all the requirements of law, of right and legitimate, lawful, by right and just title. In this sense, it is contrary of de facto. It may also be contrasted with de gratia, or de gratia, Gratia, in which case it means as a matter of right, as de gratia means by grace or favor. Again, it may be contrasted with de equitate, or equitiate, here meaning by law, as the latter means by equity. Dude, that's the best right there. That breaks it all down.
Yeah.
So, right now we have a de facto government. Does this make sense?
Yes.
And they operate under the color of law, which is not real. So, they...
It's like the thing they made up to...
That's right. So...
Yeah. Wow.
So, a de facto arrest is an unlawful arrest. So, under certain circumstances, when an officer intends to be an investigatory stop, may be transformed into a de facto arrest. For example, so it's one thing to investigate, but as soon as you find nothing, you have to fucking leave. But if you're trying to fish and fish and fish and fish, dude, you're arresting me. For example, when an officer handcuffed a defendant, patted him down for weapons, then placed him, in parentheses still handcuffed, in the back of a patrol car for 30 minutes, the defendant was effectively arrested. Even thought the state attempted to characterize this encounter as merely an investigatory stop, because police lacked probable cause. You see, they didn't have probable cause to arrest you. They went on suspicion. Ha!
Yeah. And
Well,
they detained their detainment. But
their
it's
detainment,
false arrest.
which was supposed to be an investigatory stop, which is like, I don't know, maybe fucking a minute, 4 minutes, maybe top, maybe 5 minutes.
Mm.
You only have a few minutes to stop me before it's turning into me being detained.
Exactly.
That's why you ask right away, am I being detained? They say, yeah, okay, well, what was your reasonable suspicion or probable cause to even investigate me? See, all these are holes to look for your defense. Right away! Right away!
Yeah, as soon as the first conversation happens.
Yeah, because he's not your friend, so why is he talking to you?
Right. He's gonna do all in his power to take you down.
He's Satan asking you questions, looking for loopholes inside your own character, yourself, whatever it is that fits his reasonable suspicion of a crime that leads to probable cause to you getting raped in the asshole.
Yeah.
Kidnapped.
Literally.
Yeah. So the defendant was effectively arrested. So here we go. Defendant's subsequent confession was suppressed. So even if you confessed at that point too, it doesn't matter. If the investigatory stop had no reasonable suspicion, leading into no probable cause, or let's say you were leading towards reasonable suspicion, which is an investigatory stop that actually turned into an illegal detainment, even if they found any information against you, drugs, doesn't matter, whole case dismissed. Whole case. Yep.
You may still get arrested, but once you go into court, they drop the case.
Yeah, because all the evidence was actually illegal, unconstitutional.
But you have to inform them.
You better know your shit. If not, you're gonna be run right through the cattle fucking corrals, you know?
Right, in the cage.
Yep. Right through the turnstiles. Right in front of the drive, right to the, how do you bang? How do you blah?
Right into fucking Big Bubba waiting for you.
Yep. So this is good, because it keeps going. It says, even absent other circumstances, if an investigatory stop continues on for too long, beyond the amount of time reasonably necessary to effectuate its purpose, it can become a de facto arrest. Zukor, that's Z-U-K-O-R, versus State of Florida, 488 SO.2D 601 in parentheses FLA 3D DCA 1986. Be aware that the use of handcuffs does not automatically turn an investigatory stop into a de facto arrest. So that's Studemeyer versus State of Florida, 955 SO.2D 1256 in parentheses FLA 4th DCA 2007. A suspect may be handcuffed when reasonably necessary to protect the officer's safety, in parentheses, i.e., if there is reasonable suspicion to believe that the suspect is armed and dangerous, or to thwart an attempt to flee. So you're not allowed to just handcuff somebody while you're investigating. That's actually a de facto arrest. Dude, all this is what everyone needs to know. Ha! For real.
So they can't even handcuff you unless they arrest you.
Unless they have the reasonable suspicion that you are armed and dangerous or are probable cause to be arrested. That's right.
Committing a crime
or did commit a crime, dude.
Or did commit a crime. Like
Yep.
if you go in and rob armed robbery a store, that would probably permit them to arrest.
Yes, because it says this. Court upheld handcuffing a burglary suspect while witness transported to the scene for a show-up identification. So they handcuffed him because they suspected that he would flee. Okay?
Yeah.
So the handcuffing must be temporary and last no longer than necessary to effectuate the purpose of the stop. Absent other threatening circumstances, in parentheses, such as belligerent behavior on the part of the suspect, the handcuffs should be removed once a pat-down reveals the absence of a weapon. Reynolds versus State, which is Florida, 592 SO.2D 1082 in parentheses FLA.1992.
So when they pat you down, you don't have anything, they're supposed to uncuff you.
Immediately. Yep, because if they have a suspicion that you are armed and dangerous or ready to flee, they have to handcuff you. But once you're patted down and made aware to the officer that you're not armed or dangerous, then they must release the handcuffs from you. However, handcuffing not supported by a reasonable suspicion that a suspect is a threat to the officer's safety or might attempt to flee constitutes a de facto arrest. That's Stickroth, Stichroth, verse, Florida State, 963 SO.2D 366 in parentheses FLA.2D, all capital letters DCA 2007.
That's why it'd be important to know the case law. That way you can just tell the officer right then and there, like, hey, whatever, I forget the case you say, said, or like Terry versus Ohio.
That's right.
You can execute them racing in there.
You know right away what your level of defense is from the moment you pull out your video camera evidence.
Yeah.
What's your reasonable suspicion to even be stopping me, officer? Oh man, you're already ahead of him now.
Yeah, you're asking the questions now.
Yep.
And I would let him know, I'm asking the questions.
Well, you don't even have to let him know, you just ask the questions.
You just do it.
Yep.
Yeah, you just... Yeah,
Oh, what's up, officer? By the way, I reserve all rights delegated to me by God and protected by the Constitution, recognized under the UCC 1-308 and UCC 1-103.6. Please be advised any actions commenced against me may be violation of USC 18241, conspiracy to go against my rights under color of law. I'm sure you know what color of law is. And also conspiracy to go against my rights under 242 USC 18, to deprive me of my rights under color of law. Please be advised that, basically, essentially, there's a new thing that I'm implicating into my script, which is, if you're driving and you're in a vehicle or you're in an automobile, let them know furthermore, I am not operating at a transportation or commercial use or for-hire capacity of the highway. Please note that you have been informed. And, do you want to violate or hurt me or injure me or, harm me in any way and violate my rights because I've invoked my rights? And ask him that. And then be like, what is your reasonable articulable suspicion to begin and conduct an investigatory stop? This is a investigatory stop, right? I'm not detained. Am I being detained? Okay, because you have to have probable cause, but you also have reasonable suspicion to even talk to me, to investigate.
Right.
But I just reserved all my rights. So you swore an oath to protect and serve the Constitution, right?
Yeah, you put that hand on that Bible, right, sir?
Okay, so so you're a peace officer then. Oh, great. Then that means that any actions commenced against me may be susceptible to a USC 42 1983 civil lawsuit. And also 1985, which is, are you trying to interfere with my civil rights? Because if you don't have probable cause or reasonable suspicion, that's exactly what you're doing right now, is trespassing against me. So now I can have a lawsuit against you. You see how this is working now, officer? Hey, you know what? Why don't you just get the fuck out of here?
You're working for me now.
Right. How about you get back to work, motherfucker? Isn't there a murder you should go investigate right now? Right. Real hard crime? Instead of trying to extort people? By the way, you're outside your jurisdiction. Because I'm one of the people of the several states. And I don't have to provide you with any information. You can go suck a fucking dick. How about that for information? So that's how I'm handling shit moving forward.
Yeah.
Yeah.
You have to.
Yeah. That's how I'm handling shit. Okay.
The less people that do this, they win. We should be doing this.
This is exactly what we should be doing. 24/7.
Because if we don't, then what happens is what's happening now. And we're just losing it day by day.
Yeah. I'm motivated now. So it says moving forward, okay. Similarly, the fact that an investigatory stop is effected at gunpoint does not necessarily convert it into an arrest. Okay, so you can do an investigatory stop at gunpoint and there's actually not necessarily, arrested. So they can approach you with a firearm. That's nice to know. Okay? A confession must be suppressed if it is obtained during a detention that amounts to the functional equivalent of an arrest if police do not have probable cause to make arrest. That's COPP, K-A-U-P-P, versus Texas, 538 U.S. 626, in parentheses 2003, in COPP, or COOP, or COPP, K-A-U-P-P. Although police lacked probable cause to arrest the defendant, they removed him from his home in handcuffs and transported him to the sheriff's department for questioning. The defendant's subsequent statements were suppressed, even though he was Mirandized, and the handcuffs were removed upon arrival. So, in general, the highest level of contact a law enforcement officer may have with a citizen is probable cause to arrest. An officer may make a warrantless arrest if he or she has probable cause. Florida versus White, 526 U.S. 559, in parentheses, 1999.
And that's almost what we were just going over. What makes probable cause probable cause? But now we're...
Well, here it goes. Probable cause exists where the facts and circumstances within the arresting officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a reasonable caution in the belief, to warrant a man of reasonable caution in the belief that an offense has been or is being committed. Okay, that's one. Probable cause or reasonable cause means that an officer need not have information which excludes every conceivable possibility of innocence. So probable cause or reasonable cause means that an officer need not have information which excludes every conceivable possibility of innocence. Probable cause depends upon probabilities, not certainties. Thus, it must appear to the officer that it is at least more probable than not that a crime has taken place and that the one arrested is its perpetrator. So
like if somebody calls on you, this person's going 90 down the street, lucid in. Is that really, like, does a cop now have probable cause to arrest the person that's in a lucid in, even if it's not the person that was speeding?
It's what they would use as reasonable suspicion to try to gain probable cause.
To try to gain the traffic stop.
You know, I wonder if they have this as a scenario. I know right here it talks about cautions to observe in regard to probable cause. As every citizen knows, our society is overrun with drugs, and many people rely on the police to fight this war against drug activity. The police officer must resist the temptation to use whatever means possible in fighting this war. Courts will not tolerate a violation of constitutional rights merely because it occurs in the fight against drugs. Thus, while an exchange of money or a glassine envelope, tinfoil pocket, or small vial of white powder will constitute probable cause for an arrest in most cases, not every exchange will permit an arrest. An officer may feel that if he or she sees an exchange or for any object, the courts will back him or her up should he make an arrest. This is not so. An officer must still have a reason to believe that he or she is observing a sale of drugs. Should the officer observe an exchange of an object he or she cannot see, the officer should not move in to make an arrest unless there are other factors which make it probable that drugs are being transferred. So, they do this all the time.
Yeah.
They do it all the time.
I remember when I was in medical area.
Yeah.
And woman kept saying that she contacted police because she saw two vans parked down in the parking lot. She kept saying to the police officer, "Well, they're dealing drugs." And she had said, I can't remember who brought me, but whoever brought me to the appointment questioned my physical therapist and was like, "Well, did you see the drugs?" And she said, "No, but what else is going on?"
Wow.
That the police chief couldn't do anything about it. So that's like what should happen, right? Like, they shouldn't be able to do anything about it. It could have just been two buddies down there.
Yes.
Exchanging a conversation.
Well, that's what you see now. Most people's perspective of life is to look at other people exercising freedom and assume right away that there's drug activity or something negative really going on.
Yeah.
Implied consent. The U.S. Supreme Court, so in Birchfield versus North Dakota, 579 U.S., parentheses, 2016, the U.S. Supreme Court held that a person arrested for DUI may be required to submit to a warrantless breath test to determine blood alcohol content. And it says, as a search incident to arrest, the court reasoned that the physical intrusion of a breath test is almost negligible. It does not require piercing of the skin and entails a minimum of inconvenience. The court found there is nothing painful or strange about an arrestee being required to insert a mouthpiece of a machine into his or her mouth. So, blood tests are, however, different. They require piercing of the skin and part of the thing, while humans exhale from the lungs. Having blood drawn is significantly more intrusive. So implied consent. Well, implied consent goes into a lot of factors. I figured that they would give more of a deeper connotation to implied consent, maybe something exposing the police department or the law enforcement agency and how they operate, seeing how this is their legal guidelines. They might have given a better insight on things. Because a lot of the things that they're saying in here is kind of giving us arming of helping us. As much as it's telling them what to look out for, this is all the stuff that we need to know to help us, you know what I mean?
Yeah.
So
it's like even more important to us.
That's how this book that I found out about the civil actions for deprivation of rights, and it says generally under Title 42, Chapter 21, Subchapter 1, Section 1983 of the United States Code, in parentheses, commonly referred to as a 1983 action, quote, every underlined word person who under, quote, color of law or any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress. So this is where I learned about this. The U.S. Supreme Court has ruled that an officer, in parentheses, and the department may be sued for money damages by the victim of an unlawful arrest.
I was just going to ask that.
Yep. So then it says, so it gives a bunch of case law, like Malley versus Briggs, 475 U.S. 335, 1986. Also see Hunter versus Bryant, 504 U.S. 204, 1991. City of Canton, Ohio versus Harris, 489 U.S. 37, in parentheses, 1989. U.S. versus Leon, 468 U.S. 897, in parentheses, 1984. U.S. versus Price, 383 U.S. 787, in parentheses, 1966. Also see Ortega versus Christian, 85 F.3D 1521, in parentheses, 11th Circuit, 1996. Civil rights action established under Section 1983 for false arrest and imprisonment. So it says, it is important to note that any action brought under this section of the United States Code for deprivation of civil rights has to be indispensable elements that the actions complained about were performed under 1, color of state law, and 2, by one who is a state official, i.e. a police or peace officer. And what I think they're saying is that you need to invoke your rights. You need to complain about what is being performed under 1, color of state law, and 2, by one who's a state official or peace officer who swore an oath to protect and serve the Constitution. If not,
make sure they're doing their job.
Right. If not, it basically saying that if you don't state these things, you're not protected by these things. That's what I perceived out of this by analyzing this over and over and over again. That's pretty much what I attest to it.
Right. It almost helps them as well as helps us, because they need us to tell them what the cops are doing wrong. Because if we're not saying what they're doing wrong, they assume they're doing everything right.
Well, ignorance of the law does not protect you of the law, but your ignorance also does not protect you of anything when you don't know to state, hey, you may be in violation of USC 18, 242, 241, and may be susceptible to a 1983 civil lawsuit. Like, you know, this is something that, honestly, I don't think a lot of people know about, but then when you begin to know about it, you start to realize that, hey, I have defense mechanisms here that I can use right on the scene, and if people don't know about it, then they're obviously ignorant, so now they can become victim to these perpetrators. They're not in the privy. They don't have the secret knowledge. They don't have the secret passcodes of life to help them get by, the little cheat codes, so they're not constantly molested and deprived of rights. And, you know, the more I know this stuff, shit, you know, there's people in the know and people not in the know, bro. And that's okay. They don't deserve to be in the know. You know what I mean?
Exactly.
And the more I walk towards God and know God, I'm more accountable. The more accountable, the more I walk the line and do what I'm supposed to do, the more favorable life is for me.
Yeah, it'll just unfold for you.
Pops, just drop right in my lap. That's right. That's what I'm learning. Yep. So does that help you? Did I answer some of your questions?
Oh, for sure. I love just talking about it, too. Just hearing you talk about it, I got things here and there, if that makes sense.
I'm not going to lie. You know, lately,
it's a lot of information.
I've been realizing how important repetition is. And it can get annoying and frustrating, but then you're like, well, this is it. This is me exercising a skill as a true, you know, teacher, as a scholar, and in some point by the repetition. And then I'm looking up to people. I have leaders too, you know, and these guys are leading the way for me, and I know that that's where I'm going if I stay true to what is righteous, you know. So, yeah,
what God wanted.
That's right. Get away from lust, get away from fleshly carnal desires, go more towards God and what He really wants towards us. Give ourselves fully to Him. And I think if we're going to have carnal actions, we should probably put God before everything. I've learned recently, you know, if it's done in secret, it's probably not right, man. So it's, you know, you shouldn't be doing it. If you got to do it in secret and you're ashamed and embarrassed to show people, it's probably best to not do it then.
No, that makes total sense. I'm glad you just said that. Everything happened perfectly the way it's supposed to. It's crazy how the universe and God just like, I had just had a question. You know what I mean? This all started with just a question, and then it unfolded into like this great conversation. It's amazing, dude.
Dude, I'm glad I recorded it, man. I'm still recording it. I'm glad I did that, because, you know.
And that, too, with the record now, if you go back and